What I'd like you all to recognize up until this point is the amount of doctors' names that are involved with something so out of the normal. It is so unusual the way that the defendant has been treated, and it's not the first time this has happened to someone. But it demonstrates the amount of attack that's put in, but at the same time, it's almost like all these doctors are dipping in the bucket, wanting a part of that payment system. 116. The report of Mr. Bagley adds little to the question of risk, other than setting out and advocating his views as to how the defendant can be managed in the community and why he sees the multiplicity of proposed conditions to be necessary. The HRTO Unit Management Report of Detective Sergeant James is in the same category. Section 25(3)(g). Options, if any, available if the offender is in the community, whether or not supervision that might reduce the likelihood of him reoffending over time. 117. I accept the submissions of the defendant in the respect of the potential role of the CTO in managing the risk of relevant offending. I consider the recognizance to have a lesser role given it will expire in March 2022, and it cannot be renewed, but it has some role potentially in reducing the likelihood he will relevantly offend. Section 25(3)(h). The likelihood that the offender will comply with the obligations of an ESO. Section 25(3)(i). Previous compliance with obligations under parole conditions. 118. The defendant failed to comply with his previous CCO. His failure was tied to his beliefs that were entrenched, it seems, at the time. It is hard to predict whether the defendant would comply with the proposed demanding combination of conditions proposed for the ISO and potential future ESO. He may, but the real question is whether there is a proper statutory basis to impose them. Section 25(3)(j). The offender's criminal history, including prior convictions and finding of guilt in respect of offences committed in New South Wales or elsewhere, and any pattern of offending behaviour disclosed by that history. 119. There is, in my view, no relevant previous pattern of criminal offending. Section 25(3)(k). The views of the sentencing court at the time the sentence of imprisonment was imposed on the offender. 120. I agree with the submissions of the defendant that the defendant was not dealt with as a open quote, terrorism close quote, offender, nor were the charges levelled against him framed as terrorist offences under the Code. Section 25(3)(l). Beliefs or commitments of the offender, whether of an ideological, religious, political, social, or other nature, that support engaging or participating in terrorism activities. As we move forward, just bear in mind the subject matter of the mind that we mentioned earlier, and how this was all about a belief, and what belief would be fact or truth, and what would be indoctrination being force-fed to you. 121. There is no doubt that in the past the defendant engaged in and professed beliefs of an ideological nature subscribed to by the UKOA. There is a lack of contemporaneous information as to whether he in fact still subscribes to these beliefs or not. It is at least possible that the ongoing treatment of his mental illness with medication has led to a recalibration of his delusions and previously fixed belief system. Imprisonment has also had a role. At the time of the assessment by Dr. White in June 2021, the defendant said he did not believe those things anymore. Dr. White reported no cynicism about that assertion, and there is no current evidence adduced by the plaintiff that demonstrates a contrary position. Am I satisfied to a high degree of probability that the offender poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order? 122. It seems to me that the requirements of subsection 20A and B of the Act have been met. I entertain some doubt that section 20C has been met, but I consider it just made out on a revisionary and reconstructed analysis that because some of the identified past activities of the defendant, with hindsight, he could be viewed as a, open quote, convicted New South Wales terrorism activity offender, close quote. 123. However, I do not accept that there is a high degree of probability that the defendant poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order. 124. The evidence taken at its highest is equivocal as to where the defendant currently stands regarding his beliefs or otherwise in the doctrines of the UKOA. 125. There are multiple layers of speculation involved in the material upon which the plaintiff relies to reach the proposed conclusion as to the defendant's relevant risk. 126. I also doubt that the type of activities the defendant might engage in, even if he was still a, quote, believer, end quote, would, properly considered, amount to a, open quote, serious terrorism offence, close quote. So we can see this want to further impact onto the defendant has been quashed, it's stopped. We also see that the justice uses some words in 126. I also doubt that the type of activities the defendant might engage in, even if he was still a, open quote, believer, close quote, would properly considered amount to a serious terrorism offence. Believer, belief, beliefs. And we get back to delusion, delusional beliefs, recalibration of his delusions, did not believe those things anymore, used drugs to stop him from believing those things as an intervention. So this key remark on belief at the end by the justice is directly relevant to the whole entire case, in that what's the whole reason that he was incarcerated and put under these duresses in the first place were because of his beliefs. But why was he treated in this manner by all of these doctors if it's all right to have those beliefs, and that the United Kingdom of Australia, in the blessing of Almighty God, is not a terrorist organisation, and with its curial opposition therefore cannot be defined as a terrorist organisation? I can't stress this enough. The United Nations came to New South Wales and said, "Let me in," and New South Wales said, "No, we don't want to let you in," and the United Nations requested through the federal government and then left. This is important because now, on the books, New South Wales have demonstrated that it don't want to play by international rules. And now they've been put in the hot seat by their very own actions and the actions of their New South Wales police. These agents, doctors, police officers, and in many ways the Justice Department have created this situation, and the Attorney General of New South Wales has a bit of an issue on his hands in relation to this situation, given that what I've laid out, without shadow of a doubt, falls directly under Rule 92. That's the unfortunate truth of the matter, is that what befalls the Attorney General of New South Wales right now, asides all other claims, is that what you see before you falls under Rule 92 of the international humanitarian law. You can't escape that fact.